Welcome back, ladies and gentlemen. Welcome back to the podcast. Welcome back to the podcast. Welcome back to the podcast. So, we stopped at section 39. We'll continue our discussion on the Police Act. And we stopped at section 39. We said we were discussing arrest without warrant by private persons. Now, the question is, can a private person arrest a suspect? Of course, yes. A private person may arrest a suspect in Nigeria who in his presence commits an offense or who he reasonably suspects of having committed an offense for which the police is entitled to arrest without a warrant. Okay, now where a private person arrests a suspect, what does he do? He has to hand over the suspect to the police. Okay, so where a private person arrests the suspect, he or she has to hand over the suspect to the police. Now, section 40 of the Police Act. Now, let's go through section 40. 41. A private person who will arrest a suspect shall immediately hand over the suspect so arrested to a police officer, or in the absence of a police officer, shall take the suspect to the nearest police station, and the police officer shall make a note of the name, address, and other particulars of the private person making the arrest. Okay. Where a private person arrests a suspect, such a private person shall immediately hand over the suspect to a police officer, or where a police officer is not available, you should take the person to the nearest police station. That's 41. 42. Where there is a reason to believe that the arrested suspect comes under subsection 1, a police officer shall rearrest him. And if there is no sufficient reason to believe that the suspect has committed an offense, he shall be released immediately. Okay? So where a private person arrests the person, he shall take the person to the police officer. The police officer shall rearrest him. And then where it is discovered that there is no reason to arrest such person shall be released immediately. Okay. 43. Where there is a reason to believe that the suspect has committed an offense and he refuses on the demand of a police officer to give his name and address, or gives a name or address which the police officer reasonably believes to be false, the provision of section 61 of this act shall apply. Section 61. Okay, let's go to section 61 now. Section 61 of the Police Act. What does it say? Refusal to give name and residence. Refusal to give name and residence. Where a suspect who, I'm reading section 61 of the Police Act 2020 now. Where a person, section 61 sub 1 first. Where a suspect who in the presence of a police officer has committed or has been accused of committing an arrest, triable summarily refuses on demand of the police officer to give his name and residential address, or gives a name and residential address which the officer has reason to believe to be false, he may be arrested by the officer in order that his name or residential address may be ascertained. Okay. So where a suspect refuses to give his name or residential address, or gives a false name or residential address, okay, he may be arrested by the officer in order that his name or residential address may be ascertained. That's 61. We'll still go back to section 40. Okay. Now 62. Where the true name and residential address of the suspect has been ascertained or confirmed, he shall be released on his entry of recognizance, with or without sureties, to appear before a magistrate if so required. But if the person is not resident in Nigeria, a surety or surety's residence in Nigeria shall secure the recognizance. So, having ascertained the name and the address, okay, the residential address of a suspect, he shall be released on recognizance. That's if he is in Nigeria. However, if he is a non-Nigerian, he shall provide a surety who is resident in Nigeria. Okay, he shall also be released on recognizance. Now, 61.3. Where the true name and address of the suspect cannot be ascertained within 48 hours from the arrest, and if he fails to execute a recognizance, or where so required to furnish sufficient sureties, he shall immediately be brought before the nearest magistrate having jurisdiction. That's for an offense that is triable summarily. Okay, so where his name and address cannot be ascertained within 48 hours, he shall be brought before a magistrate having jurisdiction. This is, in furtherance of a constitutional right of his constitutional right to access to justice within 48 hours. Okay. 61.4. Where the suspect on being brought before the court still refuses, the court may deal with him as it will deal with an uncooperative witness under the act. Okay. Take note. So 61. Let's go back to section 41. 40. Okay. So we're back to section 40 now. Private person can arrest. Okay. What took us to section 61 was where a person arrested refuses to give his name or residential address, or gives a false name or residential address. That was 3. Okay, so 3 says, let's read 3 again. Where there is a reason to believe that the suspect has committed an offense and he refuses on demand of a police officer to give his name and address, or gives a name or address which the police officer reasonably believes to be false, the provision of section 61 of this act shall apply. That was why we went through section 61. Now 44. Where a suspect so arrested by a private person is handed over to a police or an official of an agency authorized by law to make arrest, the police officer or official shall take note of the name, residential address, and other particulars of the private person making the arrest, the date, time, and other circumstances of the arrest, and where the arrested suspect is taken to the police station or to the agency, the police officer shall make the entries in the crime diary. Okay. Now 45. The police officer or official to whom the arrested suspect is handed over by the private person shall obtain from the private person who made the arrest a formal witness statement setting out the facts and some circumstances of the arrest. The provisions of section 46 of this act do not apply to this section unless the suspect arrested and handed over has been rearrested in accordance to subsection 2. Okay, so let's go to section 46. Section 46 of the Police Act. Inventory of property of arrested suspects. Okay. Section 46. A police officer making an arrest or to whom a private person hands over the suspect shall immediately record information about the arrested suspect and an inventory of all items or property recovered from the suspect. Okay, so section 46 is just talking about inventory of property of arrested suspects. So where a suspect is arrested, the police takes necessary inventory of his property. Okay, take note. That will be all for this podcast. In the next podcast, we'll continue from section 41, where we'll discuss arrest for offenses committed in the presence of a judge or magistrate. Arrest for offenses committed in the presence of a judge or magistrate. What's the procedure for arrest for offenses that were committed in the presence of a judge or magistrate? Thank you very much for staying with us. We'll see you in the next podcast.